The International Court of Justice, sometimes known as the World Court, is one of the 6 principal organs of the United Nations, UN. It settles disputes between states in accordance with international law and gives advisory opinions on international legal issues. The ICJ is the only international court that adjudicates general disputes between countries, with its rulings and opinions serving as primary sources of international law. The ICJ is the successor of the Permanent Court of International Justice, PCIJ, which was established in 1920 by the League of Nations. After the Second World War, both the League and the PCIJ were replaced by the United Nations and ICJ, respectively. The statute of the ICJ, which sets forth its purpose and structure, draws heavily from that of its predecessor, whose decisions remain valid. All member states of the UN are party to the ICJ statute and may initiate contentious cases. However, advisory proceedings may only be submitted by certain UN organs and agencies. The ICJ consists of a panel of 15 judges elected by the UN General Assembly and Security Council for 9-year terms. No more than one judge of each nationality may be represented on court at the same time, and judges collectively must reflect the principal civilizations and legal systems of the world. Seated in the Peace Palace in The Hague, Netherlands, the ICJ is the only principal UN organ not located in New York City. Its official working languages are English and French. Since the entry of its first case on May 22, 1947, the ICJ has entertained 184 cases through September 2022. The first permanent institution established for the purpose of settling international disputes was the Permanent Court of Arbitration, PCA, which was created by the Hague Peace Conference of 1899. Initiated by the Russian Tsar Nicholas II, the conference involved all the world's major powers, as well as several smaller states, and resulted in the first multilateral treaties concerned with the conduct of warfare. Among these was the Convention for the Pacific Settlement of International Disputes, which set forth the institutional and procedural framework for arbitral proceedings, which would take place in The Hague, Netherlands. Although the proceedings would be supported by a permanent bureau whose functions would be equivalent to that of a secretariat or court registry, the arbitrators would be appointed by the disputing states from a larger pool provided by each member of the convention. The PCA was established in 1900 and began proceedings in 1902. A second Hague Peace Conference in 1907, which involved most of the world's sovereign states, revised the convention and enhanced the rules governing arbitral proceedings before the PCA. During this conference, the United States, Great Britain and Germany submitted a joint proposal for a permanent court whose judges would serve full-time. As the delegates could not agree as to how the judges would be selected, the matter was temporarily shelved pending an agreement to be adopted at a later convention. The Hague Peace Conferences, and the ideas that emerged therefrom, influenced the creation of the Central American Court of Justice, which was established in 1908 as one of the earliest regional judicial bodies. Various plans and proposals were made between 1911 and 1919 for the establishment of an international judicial tribunal, which would not be realized in the formation of a new international system following the First World War.